Thank you, Chair. This is broadcast. At this time, we are showing 1 p.m. on our clock. We are standing by and ready for you at the station. You may start the meeting at your leisure.
Hello.
Hello. And my clock is showing 1 p.m. So I will call this meeting of the Senate Judiciary Committee to order. It is Thursday, March 4th, 2021, and I would ask the esteemed secretary to please take the roll.
Vice Chair Cannizzaro.
Here.
Senator Orenshaw.
Present.
Senator Harris.
Here.
Senator Settlemyre.
Here.
Senator Hansen.
Here.
Senator Pickard.
Please mark Senator Pickard excused.
Chair Scheibel.
And I'm also here. And today we have Patrick Guinan from LCB with us today. And as a reminder to the members of the committee and anybody else who might be expecting some legal counsel today, Nick Anthony is not with us because he's very busy drafting all of our bills, and we appreciate all of his hard work very much. That being said, he will be able to answer questions. He won't be able to answer them right now here on camera during the meetings, but Patrick, our policy analyst, and myself are taking very thorough notes, and we will be getting answers to those questions back to you in a timely fashion if you have questions that need to be answered by LCB Legal. Today we are hearing one bill. We are going to be hearing SB 22 from the Nevada Department of Corrections. After we hear the bill, we will have testimony in support, testimony in opposition, and testimony in the neutral position. Everybody testifying in any one of those three positions will have 2 minutes to speak. And in addition, I do want to point to a number of exhibits that have been uploaded on Nellis for the benefit of both the public and the members of this committee. They include an assortment of letters, different position statements, as well as an amendment. That amendment comes from individuals who will be testifying in opposition, and they will be presenting the amendment during their opposition testimony. And with that, I believe we are ready to open up the hearing on SB 22. I will hand it over to the Nevada Department of Corrections whenever you're ready.
Good afternoon, Madam Chair Scheibel and members of the committee. This is Director Charles Daniels from the Nevada Department of Corrections. I would like to take this time to introduce you to Senate Bill 22. First, let me introduce you to why we submitted this bill for consideration. Existing Nevada revised statutes require deductions in a priority sequence that conflicts with the priority sequence stipulated by the Nevada Constitution as amended by Marcy's Law legislation approved during the 2015 and 2017 legislative sessions and approved by Nevada voters on November 6, 2018. SB 22 amends NRS Chapter 209 to comply with the amended Nevada Constitution and will allow the NDOC to meet mandated compliance with both NRS and Nevada constitutional requirements. I will now turn this presentation over to James Jones, who's our Acting Deputy Director of Support Services.
Good afternoon, Madam Chair Scheibel, members of the committee. This is James Jones, Acting Deputy Director of Support Services from the Nevada Department of Corrections. Senate Bill 22 is what I'll be speaking on. Currently, NRS 209 gives the Director of the Nevada Department of Corrections the authority to determine a reasonable amount to be applied for offenders' deposits and payroll. NRS 209.247 defines the priority of deductions for non-wages, including deposits from offenders, families, and friends, and NRS 209.463 identifies the priority of deductions from wages. One of the deductions under each section is for an offender's responsibility to, quote, to meet an existing obligation of the offender for restitution to a victim of his or her crime, unquote. Senate Joint Resolution 17, commonly referred to as Marcy's Law, received approval during the 2015 and 17 legislative sessions and was passed by the Nevada voters in November 2018. The measure amended the state's constitution and expanded the rights of victims of crimes as it relates to restitution. The Nevada Constitution now states that, quote, each person who is a victim of crime is entitled to the following rights: to full and timely restitution, and to have all monetary payments, money, and property collected from any person who has been ordered to make restitution be first applied to pay the amounts ordered as restitution to the victim, unquote. SB 22 reprioritizes the existing deductions in IRS Chapter 209 to ensure the department's compliance with the state's constitution when collecting funds to be applied for restitution. Thank you, Madam Chair Scheibel and the members of the committee. We're here to answer any questions you may have pertaining to the bill.
All right, I will open it up to members of the committee for their questions. Senator Harris.
Thank you, Madam Chair. Please excuse my ignorance. I don't know much about this part of the law, but I'm wondering if you can tell me a little bit about the difference between the existing obligation of the offender for restitution to a victim and the amount that a offender must put into the fund for the compensation of victims of crime. I guess I'm wondering why we have them doing both.
Yeah, go ahead.
Oh, excuse me, if the panel doesn't mind, I just need 1 second.
I'm also going to ask those of you who are in the room together testifying, try to get as close to the microphone as possible or move the microphone as close as possible to the person who's answering the question, and state your name clearly for the record, please.
Good afternoon, members of the committee. This is Venus Fajota. I'm the Chief of Purchasing and Inmate Services for the Department of Corrections. Senator Harris, to answer your question, so one, which is the restitution to a victim, is a specific person that an offender has been ordered to pay victim-specific restitution towards, whereas the Victims of Crime Fund is a fund managed where people can apply to have payment to reimburse them. So they are two different funds.
Chair Scheibel, if I may just ask a very quick follow-up.
You may, but first I'm going to ask that the Director of Purchasing spell her name for the record if she's not signed in. I don't see you on the sign-in sheet.
For the record, this is Venus Fajota, Chief of Purchasing and Inmate Services. My last name is Fajota.
Thank you. Now please go ahead with your question, Senator Harris.
So I guess what I'm wondering is, and you know what, maybe this isn't specifically to the bill, so I apologize, but I'm wondering why, if we have offenders compensating their victims, do we need to have this additional fund that, so I'm an offender, I victimized you, I owe you a certain amount of money, but then I also have to contribute to a general fund for any other victim that someone else may have harmed? I guess I'm confused on, it seems like a bit of double dipping.
Hello, this is Jennifer Ray with Victim Services for the Nevada Department of Corrections. Jennifer, Jennifer, Ray, R-E-Y. And through the chair to you, Senator Harris, I would like to address that question because it's actually a really great question. Most people don't realize that we do have additional means that victims can seek to get bills paid. Now, the Victims of Crime Compensation Fund is generally, in most states, it's going to be funded mostly federally. It acts almost as a de facto insurance company, for instance. If I am, say, the victim of a drunk driving accident and I'm in the hospital. Those bills are going to come due regardless of the offender having paid me restitution or not. I can apply to the Victims of Crime Compensation Fund to have some of those bills met. And when those bills are met that way, they are not presented in the pre-sentence investigation report as needing to be addressed through recompense on the part of the offender. So I would not get restitution for any bills that the Victims of Crime Compensation had funded. That said, there is a limit to the Victims of Crime Compensation Fund. If I have $1 million in medical bills, and there are some that do, people who have fallen into comas as a result of their injuries, the Victims of Crime Compensation Fund is not going to guarantee me $1 million. You know, they may pay anywhere from $5,000 to $10,000 and say, I'm sorry, that's the cap. That's where we can help you. Now the rest of it is on me as the victim. Does that help?
It does. And so I just want to make sure I'm understanding. Essentially, the offender is going to pay restitution to the victim. And then, please correct me if this is not how it happens in practice. And then, let's say if one of your victims had to tap into the compensation of victims of the fund for the compensation of victims of crime, that's when you may see additional dollars go there. Is that right?
Jennifer Ray for the record. It's my understanding that anything that wasn't covered, or for instance, if I couldn't provide an actual receipt for a bill that I have, the court could not order an offender to pay restitution when there is not evidence that it has been an actual cost. So if I do not have a bill or a receipt, it is not going to be something that's going to be requested. For instance, if I'm going to require long-term care, the court is not going to order an offender to pay just for the long-term care, whatever that amount is. It's always a set dollar amount. There's always a cap.
All right, I will do some more research. Thank you.
Thank you, Senator, and thank you, Ms. Ray. Vice Chair Cannizzaro, I believe you had a question or a couple of questions.
Yes, thank you, Chair Scheibel, and I do have a couple of questions. I'm listening to the presentation and I can read the bill and I see where there is language that sort of realigns where restitution to victims needs to be paid sooner than some of the other things that are included in this bill. And I think that part makes sense to me, but I think leaving this bill just to that sort of glosses over where I think there are some inherent issues that have kind of brought this to the forefront. And certainly I was here in 17 when we voted on the resolution for Marcy's Law to go to the ballot, and am very familiar with the language there that talks about how victims are entitled to timely and prompt restitution. But this year, where the language continues to be what we consider reasonable, has sort of brought itself forward in a variety of ongoing conversations about what that reasonable number means. So I think originally at some point this last year, it had been 80%, it then was reduced down to 50. And so I guess I would like to talk about that issue, because while certainly I think we all agree that victims are entitled to prompt restitution by the Constitution, and the reordering of priorities makes sense, where I think the real issue with the policy here is with how much it is that's being taken from offenders' accounts, and basically the two separate ones. And I think I probably have different ideas on the two. One is the offender's wages, which they earn, which in my opinion, and I'm sorry, this is kind of a long statement and then a question. In my opinion, you're an offender, you've been ordered to make restitution, the crimes that you've been convicted of or pled to. That restitution that you're paying from your wages, I think, is a little different than family members who are saying, we want to send some money so, our loved one who is incarcerated can have some different food options or maybe postage options or whatever the case is that they're paying for. Because I think in that latter instance, you have the family that's paying for restitution that's been ordered from the offender. I don't think you're getting a lot of objection that some of that money should go towards restitution. But can we talk just a little bit about where it is that we're seeing this reasonable amount come from, where we've seen now decisions about 80% versus 50%, and what you as the Department of Corrections is sort of looking to be able to do with respect to those percentages?
Thank you. Thank you for your question. This is Director Daniels, Department of Corrections. I'd like to start out by saying the authority to make that adjustment falls within, at least temporarily, my discretion as the leader of the Department of Corrections. However, those decisions are then reviewed later at a Board of Prison Commissioners meeting, and those individuals at that meeting can approve or come up with options as to what we present to be the final number. So what sparked this? Well, there were 2 votes of the citizens of the state in which the legislature both brought up the issue of Marsy's Law and victims restitution. Both of those were passed by the legislature and then later voted on by the citizens of the state in the affirmative, that they put Marsy's Law in place and that they wanted to make as a priority restitution to the victims. So after that was passed, and once we realized we needed to take some action for the agency to come in compliance, I met with my executive team and we came up with a percentage of 80. Now, when we were discussing it, it was the first 20% of all monies coming in and wages would go that the inmate would keep, the offender would keep, and then we would then take restitution and so on out of the remaining 80%. After this was submitted to the Board of Prison Commissioners, there was some objection to the 80%, and they thought that it may be a better option to drop that number to 50%. So in other words, the first 50% of all wages and other associated monies coming into the inmate would then be sequestered, and that money would go towards victims' restitutions and court orders and so on. And then as we move forward, there was further discussion with the Board of Prison Commission, which the 3 primary members are the governor, the Secretary of State, and the Attorney General. So this has been fluid, but at the onset, that is part of my job requirements and responsibilities to assess and then make policies that are within the scope of my authority. Knowing though that there would be at some point review of that decision, and after, I would say, vigorous debate and discussion, a change in the 80 down to 50 was effectuated. However, they still, meaning the members of the board, put it out there for additional discussion and reconsideration, and the members of that committee decided that they would work together and see if they could come up to a more suitable solution. So that's when it left the Department of Corrections' hand and went over to the Board of Prison Commissioners. And they've been having hearings and, from my understanding, meeting with various constituency groups. So you have two groups, and the families of the offenders, but then you also have the victim advocates and the people that are supporting the victims, for which, quite frankly, Marsy's Law was drafted to take into consideration, because the victims felt as if they were not being heard. So at that point, this is how we get where we are right now. And so that's the background, and that's how the levers of this work. In my opinion, the process worked pretty well. I have the authority to make sure that I am in compliance with statute and the law, as well as the 8th Amendment of the United States Constitution. The Board of Prisons Commissioner, they're the ones that, if we make a change in our internal policies, they're the ones who will either approve, modify, or deny whatever we change. And that system seems to be working well. There's been a lot of conversation. I know that many members of every group have had an opportunity to meet with those that have an interest in this process. And so this is where we are right now. And this is why we are obviously looking at submitting SB 22, as we think it's important and it's in compliance with how the system is supposed to work. So that is my statement regarding your question. Is there anything else you would like me to respond to?
Yeah, and I appreciate that. I understand Marcy's Law. I obviously, have a significant amount of contact with victims of crime in my other daily activities. So I completely understand those issues. And I was here in 2017 when we had very lengthy conversations about Marcy's Law and hearings on that. So I'm very familiar with Marcy's Law and what it contains. Like I said, I don't think that saying that there should be a reprioritization based upon that constitutional amendment to say that restitution should be paid in a different order than what is currently in statute. I guess my question is really, because this issue is not, I don't think anybody is arguing with whether we should pay restitution before paying some other things based upon Marcy's Law, right? I don't think that that's where there's a lot of consternation about this. But what this brings forward is this decision and the authority that exists in this statute to say that it should be based on whatever a reasonable decision is. So, what was the percentage before it was reverted to 80% from what was being deposited, for example, in section 1 of the bill? What was that percentage prior to that decision?
James Jones, for the record, Senator Catazario. I would defer this over to Venus Delhova to answer.
Senator, thank you for the question. So prior to the 80% specific to non-wages, we did not deduct anything towards victim-specific restitution.
Okay, so I guess that sort of brings up the question of why change the percentage? Why not just change your policies on where you're applying those monies? Like what prompts the decision for this to go up to 80%? Because Marcy's Law doesn't say it has to be 80%, right? Marcy's Law says reasonable and timely, prompt and timely rather. And we have any number of constitutional provisions, statutory provisions, time provisions that deal with timely and prompt. That's always going to be sort of situation and case determinative depending on what you're talking about. So what prompts this whole decision to move to 80%?
Jennifer Ray, for the record, Victim Services, Nevada Department of Corrections. Through you, Chair, to the Senator. That is actually a really good question. What makes something fair? And we did look at that, and the only way that we really could compare ourselves to any other existing quote unquote fair statutes was to look at other states. And one of the first things that we realized that out of the 13 states that have Marcy's Law, our state, Nevada, and California are the only two states in the union that have a Marcy's Law with two dictates regarding restitution. One, that the victim is paid prior to funds being used for anything else, and two, that the victim is also entitled to full and timely restitution. So within the United States, Nevada and California have the strongest restitution laws in the country. So we looked at California, what do they do? And we saw that they take 50% in addition to a 5% administrative fee. And we realized we probably don't need any kind of administrative fee, but given that our laws are so similar, that would be something that we could consider. So we backed off from the 80% because we did not think that it was reflexive of what we were seeing in other states that are most like us. However, there are still other states that don't have Marcy's Law with stronger restitution components than what Nevada has. Arizona, for example, they have a specific subsection in their statute, ARS 13-804, and it says the restitution must be paid prior to financial obligations, and that the court will determine how restitution will be paid rather than their Department of Corrections. However, in Nevada, it's left up to the Department of Corrections. So we're different in that regard. Again, if you take a look at Hawaii, and these are just a few states that you can easily look at, you can access their different policies online that are still more robust than what we have in Nevada. So we knew we needed something more robust, but we also knew we needed to be fair. So really those comparisons are how we ended up at the 50% that we discussed at the Board of Prison Commission.
So, and I guess that brings up one of the questions that I'm trying to get at here as well, is you mentioned some of these other states. For example, Arizona has specific, dictates of how much this would be, whereas here our statute clearly reads the director is going to set whatever they believe to be considered reasonable. So why, there's nothing about Marcy's law that would statutorily prohibit the legislature from putting into place a particular percentage, right?
Jennifer Ray, for the record, through you, Chair, to Senator. As far as I'm aware, Marcy's law does not seek to in any way limit the way in which a state implements Marcy's law, meaning through which branch of government or to what extent. It is simply a Bill of Rights for victims that is enshrined in the Constitution so that it cannot be changed. So as far as my understanding of Marcy's law, it would be within the scope of legislature to do so.
Yeah, and I guess that sort of, and this is more of a rhetorical question, and then Chair, I'm happy to turn it back to you so the rest of the members can ask questions. But it sort of begs the question of when we're talking about reasonable and asking questions like why 80, why 50%, and the answer is, well, Marcy's law says restitution has to be paid first and foremost. That really isn't a dictate that's given by that constitutional provision, right? As long as we're putting procedures in place to pay restitution in as timely a fashion as possible, which I think the language here certainly does, but the other issues that surround this with regard to how much we are taking from various things. And again, I think there's a difference between when the families are giving money versus when an offender has wages that we are taking. Those are really policy discussions that I think give me just some questions about whether it would be more prudent to put something in statute that doesn't give discretion, because to me, Marcy's law is not the reason for why we see percentages changing, right? There's some sort of other reason why we would bump it up to 80% or bump it down to 50%, and that may change in the future. And so I wish there was a better answer than this was just Marcy's law, because the language of Marcy's law doesn't say 80 or 50 or any particular percentage. And I guess that's more of a comment than it even was a rhetorical question. Chair, I'll turn it back over to you.
Thank you. I think that you elucidated a lot of the questions that a lot of us have. So I appreciate that, Vice Chair Cannizzaro. And I'll move next to Senator Orenshaw.
Thank you, Chair. And a couple of questions. I want to follow up a little bit on the majority leader's questions. And I know that it's a fine balance trying to, make sure that victims are made whole, and also trying to not dissuade anyone who's incarcerated from participating in work programs, from family, trying to help them while they're at NDOC. But right now I want to turn to page 4 of the amendment, and I wonder if anyone from NDOC can describe what they envision with this quarterly package program, where they arrived at the $300 maximum, amount, and the restriction on the ability to take part in that. If someone's in disciplinary segregation, is that something like that currently happening with use of funds on an inmate's account, or would that be something new that would be instituted here in this bill?
I'm going to interject real quick, Senator Orenshaw. Are you referring to the amendment that has been proposed by the Return Strong and the ACLU and the Nevada Attorneys for Criminal Justice.
Oh, I think I'm looking at the green language on page 4. Okay, I apologize, Chair. Yes, I am.
I have no problem with you asking the presenters. They've also received a copy of this amendment if you want them to speak to what's in the amendment and their response or opinions on it. I just wanted to be clear that this is not coming from the Department of Corrections. This is coming from Return Strong Families United for Justice of the Incarcerate, the American Civil Liberties Union of Nevada, and Nevada Attorneys for Criminal Justice.
That is what I was referring to, Chair. And if anyone from the department could comment on how that could be implemented, if that is the final language. Thank you.
Venus Fajota, Chief of Purchasing and Inmate Services. Senator Orenshaw, thank you for the question. We currently do provide a quarterly package program where inmates and outside parties can purchase clothing, hygiene, food items. The amendment submitted for your consideration is actually more restrictive than what our current program allows. So we actually allow a $425 limit quarterly for most of our locations for food and clothing. And then actually at our transitional housing facilities, we have a monthly limit. As far as disciplinary restrictions, I'll have to turn that over to Deputy Director Wickham.
For the record, Deputy Director Harold Wickham, Department of Corrections, through the chair to the Honorable Senator. As far as disciplinary segregation, we typically do not allow the package program for disciplinary segregation due to the fact that there's obvious reasons they're there for a disciplinary reason. So we don't allow the amenities that come in the packages. We also don't allow it in our medical division, and that's typically based on doctor supervision, because we don't want people ordering a bunch of honey buns if they're in there for specific reasons. So that's the primary reason. And then there's a space issue when we're concerned with the medical facilities. There's just no storage space there because it's a temporary housing unit. I hope that answers your question, sir.
Thank you. And Chair, may I have one brief follow-up?
Yes, go ahead.
Thank you. Then, other than that difference between the $300 per quarter and the $425 value of the package, this proposed language on page 4 of the amendment seems to follow what's currently done by NDOC?
Venus Fajota, for the record, yes, Senator, you are correct.
Thank you. Thank you, Chair.
Absolutely. And that brings me to a follow-up question. Without the amendment, will the Nevada Department of Corrections continue to with its current package program?
Venus Fajota, for the record, yes, Senator, we would continue the package program.
All right, thank you. And do any of the other members of the committee have questions? I am not seeing any questions, so we will move on to testimony in support of SB 22. Again, testimony will be limited to 2 minutes per person. If you wish to testify, please click, and you have not already done so, please click on the participate button next to the agenda on the Nellis website. You'll be prompted to provide your name and email address in order to get the phone number to call in. For those who have already called in, I will ask our fantastic staff at BPS to go ahead and have them queue up and begin the support testimony.
Thank you, Chair Scheibel. To testify today in support on Senate Bill 22, please press *9 now to take your place in the queue. Once again, to testify in support on Senate Bill 22, please press *9 now to take your place in the queue. Caller with the last 3 digits, 915. Please press *6 to unmute, then slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Yes, hi, my name is Joseph Chorak. That's Joseph. Last name is Chorak. I stand in support of SB 22 as a victim of a violent crime. My son was nearly murdered at the hands of two brutal individuals who stabbed him in the throat, stabbed him in the back, and by the grace of God, he lived. He has scars to this day and nightmares. They have sat in jail, refused any kind of restitution. He is not only being victimized at the time of the attempted murder, but he was also victimized today and reliving this. He has well over $80,000+ in medical bills. He has received less than $1,000 in restitution. Judge Mosley sentenced them to 34 years. Both have got out on parole. Both have left the state. One has violated parole and is now back in custody. She has not paid a dime. She sat in jail and got an inmate website. My son, to this day, 10 years after, screams in his dreams, reliving this brutal murder. 8 pints of blood required to him to survive. They could not find a pulse until the crime investigator came. Sit there and victimize him again is unconscionable. And I will stand in support of it. And I want you folks, you senators, to put yourself in my shoes. If this was your child, what would you want? Forget about the rights of a criminal who thinks nothing of taking someone's life and attempting to take someone's life. This is not stealing a pack of gum. This was murder, attempted murder. And to sit there and go ahead and give them this venue is an insult to everybody who obeys the law. Thank you for your time today.
Thank you, caller. Caller with the last 3 digits, 389. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Thank you. My name is Jennifer Noble, JenniferNoble, speaking on behalf of Nevada District Attorneys Association. We are in support of this bill, and we'd like to thank the Department of Corrections for bringing it before this committee. Thank you.
Thank you, caller. If you've recently joined our call this afternoon, we are currently on support testimony for SB 22. If you would like to give support testimony on Senate Bill 22, please press *9 now to take your place in the queue. Caller with the last 3 digits, 400. Please press *6 to unmute yourself. Then slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Hi, my name is Julie. Last name is spelled Kim, Kim. I am in support of this bill 100%. There is no amount of compensation enough to ease the victim's suffering. It should be 100%. In the 15 years that I've been victimized, I've been paid a total of $120. I can't even imagine, can't even begin to tell you how my suffering is just, it's a lifetime. And 80%, that's just, it's not enough.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to give support testimony at this time.
All right, thank you. I'm going to ask one more time if there's anybody left who wants to give support testimony. I'm sorry, Mr. Kyle, is it *6 or *9 they need to press?
No problem, Chair Scheibel. It is *9 to take your place in the queue.
All right, I'm going to give you about 30 seconds to hit *9 and enter the queue. This is in support of SB 22. And Mr. Kyle, is there anybody in the queue at this point in time?
Chair Scheibel, there is no one to give support testimony at this time.
All right, in that case, we will close testimony in support of SB 22. We will open testimony in opposition to SB 22.
Thank you, Chair. To testify in opposition on Senate Bill 22, please press *9 now to take your place in the queue. Once again, to testify in opposition on Senate Bill 22, please press *9 now to take your place in the queue. Caller with the last 3 digits, 725, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Hello, and thank you, Chair Scheibel and committee members. This is Nick Shepak, SHEPACK, Policy and Program Associate with the ACLU of Nevada. I want to give you all a brief history of the inmate trust account issue. NACJ will speak to the amendment, and Return Strong will address some confusion with the package program part. In September of 2020, without warning to incarcerated individuals or families, the Nevada Department of Corrections began garnishing family deposits to funds and money currently in the trust account at a rate of 80% for those who owe restitution. 77 pages of letters from currently incarcerated individuals from this time have been submitted as an exhibit to help you understand the issue and the importance of statutory caps on deductions. This led to a large outcry from families and families of the incarcerated and advocacy organizations, which garnered a good deal of media attention. The 80% deduction was struck down during an October 8th Board of Prison Commissioners meeting, and NDOC was instructed to work with the Secretary of State to develop a more acceptable deduction scheme. NDOC was also instructed by the governor to revert to the old AR, and which included a gift coupon program, and to meet with impacted families. NDOC refused to meet with families and did not reinstitute the gift coupon program while working on the new AR. Despite many attempts by our organization and others, orgs, no advocacy organization or impacted person was a part of this conversation. The Board of Prison Commissioners met again on this issue on January 25th. There was no document available to review before the meeting. A deadline for written comment was originally set at noon 6 days before the meeting. A decision was made to temporarily cap deductions at 50% while NDOC prepared a new AR reflecting this decision. The deduction started without warning just a few days ago. We had a meeting with NDOC recently to try to find some common ground on our proposed amendment for this bill. While we appreciate them taking the time to meet with us, they were not willing to work with us at that time. Our meeting, however, did help us understand that NDOC's legal team believes that a gift coupon program is unconstitutional, but a package program is not. That is why we have gone with a package program in our proposed amendment. We'd like to see to ensure that that exists in a robust fashion moving forward. We are unfortunately here today to present an unfriendly amendment, and we hope to come to a consensus with this body and NDOC. You will hear more from the other presenters. Thank you so much for your time.
Thank you, caller. Caller with the last 3 digits, 656. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Hi, good afternoon, Chair and members of the committee. My name is Will Pregman, W-I-L-L-P like Peter, R-E-G-M-A-N. We stand opposed to SB 22 as written. However, we rise in support of the amendment proffered by ACLU and Return Strong for the following reasons. Without statutory protections, families of the incarcerated are left in an extremely stressful situation where they're unsure if they'll be able to provide for their loved ones who are incarcerated. We urge NDOC to work with the impacted families, advocate organizations, and legislators to find a balance that protects both families of the incarcerated and the victims who are owed their due restitution. Families need clarity of how much money they can expect to be deducted from their deposits. Caps will help with, and the caps will help with this. While everyone agrees that victims deserve restitution, the burden of restitution should not be placed on the family members of those incarcerated. Thank you for your time.
Thank you, caller. If you have recently joined the call today, we are currently on opposition testimony on SB 22. If you'd like to provide opposition testimony, please press *9 now to take your place in the queue. Caller with the last 3 digits, 151. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon. My name is Denise Bolaños, DENISE and I would like to testify today in opposition to SB 22 as it stands now. I feel that there are ways to make this bill as fair to families of the incarcerated people as it does to victims, because regardless of how we want to word it, it is primarily our money that's being garnished. Money that I send my husband so that he can buy things like toothpaste, soap, and detergent, things that help maintain cleanliness and good hygiene. These things are always important, but during a pandemic, even more so. It's inconceivable to me that the $100 that I manage to send my husband every month would no longer be enough. I work a full-time job and a part-time job, and we have 6 kids between us, and living from paycheck to paycheck is hard enough. And yet, despite that, how lucky am I that I still have a job at this point? So many others are not so lucky. So imagine being in that same situation while also facing housing and job insecurity, on top of all the difficulties we face day in and day out while having family members incarcerated. Because regardless of who they are, what they did, they are still our daughters and our sons, our brothers, our sisters, husbands, and wives, and they are still human beings. I have been both the victim of a crime and now I'm the wife of an incarcerated individual. And I personally did not choose to become a victim when I was 13, and I also did not victimize anyone myself. So while I realize that victims are entitled to restitution, I do not believe that anyone except the person responsible for the crime should be held accountable for it. I did not and still don't expect that man's wife or his adult kids to pay for my medical expenses. By garnishing it from what families deposit on these accounts, you are in fact taking it from us. Thank you for your time.
Thank you, caller. Caller with the last 3 digits, 080. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Hi, Jim Hoffman, representing Nevada Attorneys for Criminal Justice. Similar to what Mr. Shepak stated, we currently oppose this bill, but we would support it if the proposed amendment on Nellis were adopted. I'm here to explain the amendment. The overall goal is to establish a predictable, transparent process so that both inmates and victims know how things are going to work, while not preventing families from supporting inmates in their attempts to rehabilitate. To explain the specific provisions, the amendment basically makes 4 changes. First, it would cap wage deductions at 50%. This is the amount currently present in regulation, but the amendment would put that into statute to make things predictable for everyone in the future. Second, the amendment would cap family deposit deductions at 25%. Third, the amendment would allow families to deposit up to $300 once per quarter without any deductions. I know there were some concerns with this part of the bill. I'll let Return Strong address that, but I want to note that we would not have a problem with changing that amount to reflect current practice. These 2 changes would ensure that families are able to pay for a minimal amount of things like food, postage, or anti-COVID cleaning supplies without just having that be confiscated. Finally, the amendment would require NDOC to give what are essentially bank statements to inmates so that everything is transparent and predictable for inmates and their families. We believe this amendment would strike an appropriate balance between the needs of inmates and their families, the needs of victims, and the administrative interest of NDOC. We urge you to support it. Thank you.
Thank you, caller. And if you've recently just joined our call this afternoon, we are currently on opposition testimony for Senate Bill 22. If you'd like to provide opposition testimony, please press *9 now to take your place in the queue. Caller with the last 3 digits, 656. Please Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin now.
Hi, my name is Amanda Candelaria, AMANDACANDELARIA, and I'm here in opposition of SB 22 as it stands right now. My loved one is currently incarcerated at NNCC, and we would be greatly affected by the changes that NDOC is trying to implement for the inmate deductions. His mother and I have been supporting him financially when we were able to, but due to COVID-19, his mother is no longer working and is on a very fixed income. I myself work full-time, but I have children and grandchildren of my own to support. Still, we do what we can. Even the current 50% being taken out is too much of a burden. Our loved ones needs to be able to use the money we send to order healthier food choices and basic hygiene items that are not provided by NDOC. At the current rate, we won't be able to send any money at all. Wouldn't it make more sense to lower the deduction amount to 25% so something can be taken out for what he owes rather than have it be at 50% or higher and we send nothing? Also, in other prison systems, such as California, family members are able to order weekly commissary online for their loved ones. Would it be too much to ask for NDOC to look into doing this also? We fully understand the obligation our loved one has to pay his restitution, but please understand that this is his obligation, not ours. Please don't make it harder on us financially than it already is during these hard times. Thank you.
Thank you, caller. And if you've recently joined us this afternoon, we are currently on opposition testimony for Senate Bill 22. If you'd like to provide opposition testimony, please press *9 now to take your place in the queue. Caller with the last 3 digits, 926. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon. My name is Jenna, Jena Chapman, Chatman, and my husband is incarcerated in NDOC. I want to try to explain to you some of the things that haven't been said yet. My husband was brought to Nevada for a parole violation. He didn't submit his change of address. Now he is back in prison, finishing his time. Right before he was moved, he was diagnosed with stage 3 prostate cancer. While we are not personally impacted, I want to address some of the things that cause additional impact for families with these deductions. Yes, we send money for food and hygiene, but we also send money for their medical treatment. Nevada is the only state in the country that has not ended medical copays for inmates during COVID. So our loved ones still pay $8 for medical care, and if they don't have it, we will have to pay it one way or another. The idea that they are worth of the state and are taken care of is just not true. So if the deductions leave you indigent, you don't have the $8 to see medical, or even worse, if your medical condition worsens, you have to call man down, which is like 911. That will cost you $85. During COVID, NDOC did not freely make remedies available like most states. They charged our loved ones for the most basic remedies. The nurse at Gene Conservation Camp stood in the front of a dorm of women who were all sick with cough drops and telling them it was $10 for 6 to 8 cough drops. When the director deemed it reasonable to take 80% and now 50% of people's money for restitution, it is the reality of survival that was left out of the story. When he is questioned at the Prison Board of Commissioners or the Sentencing Commission or here, he doesn't ever tell the whole story. I don't know why. Either he is that out of touch with reality of what is happening, or he just doesn't care, or he lies. There are not very many options, and I don't know the answer. But I know this. What happened in September and is happening now is not reasonable. I understand that reasonable, like timely, is subjective but without definition. The director has proved himself unreasonable, and we need to make sure that he can't be given the power to make decisions like this without someone providing true oversight. I have no choice but to be in opposition of SB 22. Our very lives depend on you protecting us from the whim of the director. Thank you.
Thank you, caller. Caller with the last 3 digits, 752. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon. My name is Lavina Wagoner, LAVINA WAGONER, and I have a loved one at NDOC who has been impacted by the deductions, which then puts the additional burden on our family. We are already living without his income, and now to make sure he would be okay, we would need to send extra, which honestly we just can't do. We are in opposition of SB 22 because honestly it has created a disaster for incarcerated people and their families. We received a letter from a woman at Gene Conservation Camp that was so upsetting. She has worked to get a place where she is rebuilding her life. She is at Gene and working for NDF. She wrote this: I think it is just wrong to take money from our families and put on our books to help us. I understand that our victims deserve restitution and understand fines and fees should be taken from any prison earned wages, but not from the money our families send. This is not their responsibility, and sadly, they already pay the cost financially and do the time emotionally with us. It is hard to understand when you aren't living it. At the camp, we have multiple sets of various overpriced clothing items to work for NDF. In addition, at camp, we pay for room and board, fire packs, and other random things. We make almost no money working for them and can't get a job with them once we are free. But now, even the money my family sent to allow me to purchase these work-related items is gone. I am basically forced to work and hustle around the camp to obtain what my family already tried to provide for me. I am doing everything in my power to get my life together, but it feels like a fruitless endeavor. It feels hopeless. Was this a point of Marsy's Law? I don't think it was. I'm asking you today, for all the reasons that I have mentioned, to protect us in any way you can from the director deciding what is reasonable. He has proven that he should not have power. Thank you.
Thank you, caller. If you've recently joined our call this afternoon, we are currently on opposition testimony for Senate Bill 22. If you'd like to provide opposition testimony, please press *9 now to take your place in the queue. Caller with the last three digits, 779, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Hello, my name is Nicole Tate, T-A-T-E, a registered voter in Senate District 8. I'm calling in today for opposition of SB 22. The addition of Marsy's Law to the Nevada Constitution was said to have inspired these changes. However, the verbiage of Marsy's Law states for victims to receive full and timely restitution. While the NRS does include definitions for a vast variety of terms, the definition of timely does not exist. Timely, a word that could have different definition for different people. In addition, is the period of time while one is incarcerated the most appropriate time to start collecting these funds, as even if employed, are only making slave wages at best. Let's face it, the only funds an incarcerated person can really use are the ones sent in by their family members. Once an individual is released and on parole or probation, restitution is still owed. NRS 176A.430 allows someone in danger of violating those conditions for failure to pay restitution to be entitled to a financial hardship hearing. This is while someone is out of prison and able to make at least a minimum wage. How is it determined that someone who does not have the same ability of wage earning be held to a higher standard as there is no financial hardship hearing capability for them or their family, even during a pandemic when a large portion of people are suffering financially? Family members who wish to send funds to support the hygiene and food needs of their loved ones, as what is provided by NDOC, is not adequate. I don't believe the spirit of Marsy's Law was meant for the families of the incarcerated to be the ones financially responsible for the payment of restitution. I have dealt with similar type of financial deductions from NDOC for medical bills from an injury my husband incurred while incarcerated. For every $100 I sent, he received approximately 30. Now, I had the ability to pay extra to allow him to get the things that he needed, but not everyone has that option. And just as an added note, packages are not and have not always been available to every incarcerated person, even those not in segregation. In addition, I would like you to invite you to inspect the price differences of package items between Nevada and California. Prices here are substantially higher. These are just a few reasons why I would like you to vote no as SB 22 is written. Thank you for your time and consideration.
Thank you, caller. Caller with the last three digits, 833. Please press *6 to unmute yourself, then slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Hello, my name is Jennifer Henry, last name Henry, and I have a loved one incarcerated in NDOC at NNCC. But I'm here today to share a story from another family who was directly impacted by the revisions to AR 258, which is how we all ended up here, begging for our representatives to listen to the harm the deductions have caused, not just to incarcerated people, but to families and by default our communities. Since September 1st, I have stood with other families and have seen the distress that it caused. The family I am representing is unable to attend today due to working, and they can't risk losing their jobs and asked me to speak for them. This family has sacrificed during their child's incarceration in order to help him be able to turn a new leaf and redeem himself from the choices he made that were never intentionally criminal, but were due to abusing drugs. She says, I am writing this letter under much distress due to the decision to deduct funds from my son's account. It is unreasonable to believe that this decision does not victimize families. The way the deductions were taken, first at 80% and now at 50% without warning, blind-type families. I understand there are victims who have not received restitution for the crimes committed against them. I am not insensitive to their pain. However, restitution is the responsibility of the person who committed the crime when he is released and begins the process of restoring what is required of him or her. I send money to my son for tuition. It has been an investment in my child to help him find a new direction when he is released. By taking these funds this way, NDOC is robbing him of the opportunity to voluntarily restore what he broke and robbing me of the ability to provide the foundation for a different direction for him. Families were never meant to pay full and timely restitution. The state of Illinois, also a Marsy's Law state, has created that holds the offender responsible for restitution. They allow a person 5 years after release to repay their restitution. I am in opposition of SB 22. The director has not been responsible in his decisions. He has not been reasonable, and I fear the power that is given him in this bill. Thank you for your time.
Thank you, caller. And if you've recently joined our call this afternoon, we are currently on opposition testimony to Senate Bill 22. If you'd like to provide opposition testimony this afternoon, please press *9 now to take your place in the queue. Caller with the last 3 digits, 209. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Ashley, A-S-H-L-E-Y, White, W-H-I-T-E. Hello, my name is Ashley and I live in Senate District 10. I am here today with so many different emotions. The past several months have been a roller coaster trying to deal with all of the confusion of how or why the director thought that it was reasonable to take 80% plus of anyone's income with no notice during a pandemic. I mean, it was bad enough dealing with the pandemic out here, but to add that to wondering what happens to my loved one if he gets COVID in there, but then he got COVID. I remember when all of this was happening, it didn't feel real. I have 2 young children. One is severely autistic. I literally took all of my money and sent him a package with $275 of bars of soap and lotion and deodorants because I was watching everything run out on store shelves out here and was terrified of all the things that could go wrong if he didn't at least have soap. He is diabetic and 57 years old. It was crazy. Real fear and panic. I sent him the rest of the money I had and then I lost my job due to the pandemic. Then the director thought it was reasonable to take 80% of the money I sent for victim restitution and left all of us struggling. It was like being caught in a landslide that just wouldn't stop drowning me. I was helpless to fix it. We had kids out of school, no job. We didn't have what we needed, but he was even worse off, and all I could think of was what happened if we lose him. What if his sentence with an out-of-date becomes a death sentence? Then it is your family you make the sacrifice to make sure you know they are safe, even if that means we hit food banks. We could survive and protect ourselves out here, but what was he going to do with a hotel-sized bar of soap, a roll of toilet paper, and one threadbare mask to last for months? All of these things together have created anxiety that makes life barely functional some days. We all are loved ones. All the families need some certainty. The director has ripped the rug out from under families twice. He did it again March 1st. I oppose SB 22. Please give us some hope and protection. Thank you.
Thank you, caller. Caller with the last 3 digits, 943. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hello, my name is Lauren Meek, Laurenmeek, and I am registered to vote in SB 13. I'm here to support families of the incarcerated and incarcerated people in opposing SB 22. I'm sharing a letter in response from a family who was impacted by the revisions to AR 258 and share their concerns. The letter states a consistent problem that NDOC has been unwilling to acknowledge, which is the problems with accounting when it comes to restitution. People have money taken through deductions that never reflects correctly between parole and probation and NDOC. Consequently, people end up continuing to pay on cases that have long since been paid off, and for the record, incarcerated people have little ability to get that corrected, if any. This writer says, this month, out of the $400 that was sent to me, I am able to spend $59.17 on Canteen. This is for restitution that I do not believe I even still owe, and have grieved with no response. It is from an expired case in 2007. My family doesn't owe restitution. They never did. I am currently out of most supplies to write my family, such as stamps and envelopes. I can't get them for free because since I get money, even though the deductions leave me in indigent status, I am not considered indigent. I haven't been able to afford phone time to call my 5-year-old son. It's crazy because I heard about the director saying that families can buy phone minutes for us to call them, which is true. What isn't true is that my ex isn't going to buy phone minutes for me to talk to my son. I budget that out of the money that I have coming in. Tell the whole story, Director Daniels. This policy is devastating my family because they love me and want to make sure I am okay. I am not proud of my crime, and I think of my victim often, and I want to pay the restitution. No one needs to force me to do it, but give me the chance to fulfill my responsibilities. Don't allow NDOC to take it off the backs of the people who love me. I stand with families and incarcerated people and oppose SB 22 and agree with them. Two truths can be true. We can care about victims and incarcerated people and their families. It doesn't have to be one or the other. Thank you.
Thank you, caller. Caller with the last 3 digits, 846. Please press *6 to unmute yourself. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hello, my name is Adrian Lowry, L-O-W-R-Y, and I live in Vote-In Senate, District 15. I'm here today with Return Strong to read a letter from an incarcerated person, a person who is hidden from society, a person on death row. It's on his behalf and his family and other families of the incarcerated that I'm here in opposition to SB 22. He writes, "The crime I committed, I believe was horrible and I deserve the consequences that come with it. What bothers me about my sentence, however, is how it affects my family, who love me. For they are innocent, law-abiding people with love and compassion in their hearts. It seems unjust to punish them by association for my crimes. I've already seen firsthand how much pain is spread exponentially by one death or murder. The restitution I am ordered to pay is confusing to me, however, because I am legally forbidden from earning a wage, by default because I am on death row. I live in isolation due to that status until the day I am executed. I'm not allowed to participate in activities in general population, including rehabilitative programs. I'm condemned to death without hope or expectation of rehabilitation. You can't have it both ways, though. Either you want me to pay for my crimes monetarily, or you want me to pay with my life. But I can't do both, and Marcy's law and Nevada's implementation of deductions does not account for any of that. Life on death row is lonely and miserable, and the state does not provide adequately for a person to survive in isolation. Out of love, my family provides me financially so I can buy clothes to wear, stamps, and phone time to communicate with them, food, coffee, art supplies, and a handful of appliances so I don't lose my mind and humanity altogether. Under normal circumstances, conditions at Ely and death row are deplorable. With the pandemic, it's even more intense. The pandemic has affected my family with illness and job loss, and then this revised AR and the deductions. SB 22 is not about deductions, it is about power. The director doesn't need a bill to order deductions, and we all know it. He needs it to retain unchecked power. We oppose SB 22, myself, this writer, and our families. Thank you.
Thank you, caller. Caller with the last 3 digits, 271. Please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon. My name is Tammy Irvine, T-A-M-I-I-R-V-I-N-E. My loved one is incarcerated at High Desert State Prison, and I live in Senate District 3. I am in opposition to SB 22 and will read a letter from a member who couldn't attend today because they are at work. This is what she wrote regarding her family experience during the time the director implemented the deductions. My name is Laura, and I'm writing in regards to an experience last fall when money was taken from inmate accounts. My husband is incarcerated in Nevada. He wasn't personally impacted, but the truth is we are all in a horrible position. This decision impacts us all, inside the prison and outside. Inmates who have money and who don't. My husband immediately noticed a shift in the dynamic on the tier. Inmates who no longer have money are pressuring other inmates who do to purchase for them because survival kicks in order to achieve their highest level of humanity. They must have their basic human needs met. The deductions partnered with the impact of the pandemic, extended lockdowns, no contact with their families because visits have been stopped for a full year, along with the aftermath of the destructive COVID outbreak. It has been traumatic for both people inside the prison and families outside. We can't continue this way. As a concerned wife, citizen, and voter who actually supported Marcy's law when it was on the ballot, this is not what I believed it would be. This is an abuse of power, and the only opportunity to stop it is to stop the passing of SB 22. I oppose SB 22 in its current form. Now, speaking for myself, it is concerning the director is now choosing to implement this deduction because even 50% is outrageous. What would you do if you woke up one morning and 80% of everything your mother owned was gone and she suddenly lived on 50% of her income? You would find any means necessary to help support her? Our families do not have a choice. The pressure will be on us to find a way to be there for our loved ones. I am in opposition of SB 22 for all the reasons I have stated and for the fairness of basic human needs. Thank you for your time.
Thank you, caller. And as a reminder, we are currently on opposition testimony for Senate Bill 22. If you'd like to provide opposition testimony, please press *9 now to take your place in the queue. Caller with the last 3 digits, 826. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hi, my name is Ayana, Ayanna Simmons, Simmons. Hello, members of the Senate and all who is involved. Thank you for taking the time to hear me today. My husband and brother are incarcerated in Nevada Department of Corrections. Like many others you have heard from today via letter and voice, our family has been affected by the garnishments placed on inmate accounts. Director Daniels deemed it reasonable to deduct up to 80% of the money received by inmates to pay restitution. Now that plan is 50%, but at no point in this process did the director do what was asked of him by the governor, which included to sit down with families of victims, families of the incarcerated, and key stakeholders and find a solution that would meet the requirements of Marcy's law and be fair to families and our loved ones. He said that it's only impacted 1,800 people that specifically owe victim restitution, but the cost of incarceration is high. And ultimately, families pay for it to keep our bonds with our father, mothers, grandparents, children, phone minutes, quarterly packages, money on their books, and etc. It's all expensive. These garnishments is falling on us, the families of prisoners in Nevada. We and our children are paying the price and impact to these deductions. When this first happened, we sent a test amount because we had no idea what was going on, and I couldn't afford to lose the little money I had. So I sent $20. He received $4 of that. The state left him indigent with less than 10 in his account. The money we send is not for luxury. It's for basic necessities, hygiene, food, and things of that nature, which they currently receive is not sufficient, either in quality or quantity. Do you know that during the COVID outbreak, Return Strong received letter after letter after letter from different facilities, everyone with the same thing, lack of food and different things. A hard-boiled egg and a piece of bread for breakfast. People reported a slice of bologna and a pack of mayonnaise and packs of salt and peppers for a bag lunch, oatmeal with maggots at NNCC. We send money for food because it's a necessity. We must remember that regardless of crime and culpability, our loved ones are human before they are inmates, and as such, they are worthy of being loved and thought of and cared for. The money we send to our loved ones is how we can convey those things, especially at times like this, when we are unable to physically see or touch them. These are very trying and unprecedented times with all that is happening around us, and we are struggling, whether it be financially, emotionally, or physically. The garnishment adds so much weight to us. Already heavily situations, and it's my hope that a solution
You're a little over 2 minutes.
Found.
Testimony.
SB 22 is not the solution. I'm a voter in District 15. Thank you.
Thank you.
Thank you, caller. Caller with the last three digits, 499. Please press *6 to unmute yourself. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hello, my name is Jody Hocking, and I'm the founder of Return Strong Families United for Justice for the Incarcerated. I'm also part of an impacted family, as my husband's at NDOC and is impacted by restitution. Personally, I feel like I've been living and breathing this fight since September 1st. I could have just paid his restitution and called it a day, but something about this feels wrong. Feels wrong for the burden to be put on me, even though I love him and forgive him for the choices he made to end up back in prison. His restitution is purely his. I don't own any part of that. Then I started thinking about the pieces of injustice that are part of this system. Incarceration doesn't mean that justice was served. It doesn't define a moral line between victim and offender, and it doesn't always equate to right or wrong. It just means that one person has a debt that is owed to another. I've obsessed about this for months. I kept thinking about it, and I came to the point where I really have been focused on two words. They've been thrown around today multiple times by both sides, and the first one is reasonable. I decided to go look it up because I wanted to do more than say it doesn't feel reasonable. So reasonable is two things. One, it's having sound judgment, fair and sensible. The second definition is as much as is appropriate or fair or moderate. The way the director approached his decision regarding inmate deductions did not follow any of those criteria. It wasn't reasonable in any shape or form. Even under Director Daniel's own current explanation today, it was so completely random. It wasn't made with sound judgment. The second word that I keep thinking about is timely, and that's defined as occurring at a favorable or useful time. When you apply that to inmates trying to pay restitution when they aren't unable to work, it doesn't seem like that is a relevant term, even though it was put into the Constitution. NDOC repeatedly brings up states that have more robust Marsy's Law requirements, but what they don't talk about are the states that have more fair Marsy's Law process, like South Dakota, that allows offenders a sliding fee and to create a budget with their caseworker. Ohio, inmates only pay 25%, but only from work programs. Illinois doesn't take restitution from inmate accounts. They have 5 years post-incarceration to pay that debt. Why does NDOC only mention the states that are more aggressive instead of all of the information, the whole truth, not a half-truth, so that we can truly deem what is reasonable? I want to make one more comment. Obviously, I'm in opposition. I just wanted to say regarding the amendment is for an increase to $300 quarterly for the food package, which is currently $150. That's where the misconception is coming in. So we're looking to increase the amount of the package for the food package. The clothing package could remain the same. Thank you.
Thank you so much.
Thank you, caller. If you've recently joined our call this afternoon, we are currently on opposition testimony for Senate Bill 22. If you'd like to give opposition testimony, please press *9 now to take your place in the queue. Caller with the last three digits, 099. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Valerie O'Neill, VALERIE-ONEILL. Good afternoon. My name is Valerie, and I'm a voter in Senate District 12, and my son is incarcerated in Nevada Department of Corrections, and I'm here to try to express to you how horrible this has been on incarcerated people and on their family. There are some things you just may not understand about life as a prison family, and today I want to try to paint a picture of what life is like, especially when the director deemed it reasonable that up to 100% of a person's income could be taken for victim restitution. My son doesn't owe victim restitution, but I stand with families and people you will hear from today, and I'm going to tell you the story of a woman from Gene Camp who wrote to Return Strong about the devastation that this caused. She works for the Nevada Division of Forestry and does a variety of jobs in the prison, but the prison doesn't provide her the things she needs to do her job. She has been saving for thermals and a coat and sweats and gloves to be able to stay warm while working along the side of the highway this winter. So she woke up on September 1st and her money was gone without notice. Her family has lost all their jobs due to living in Vegas during the pandemic and are not able to help her. As a matter of fact, she sent some help for her grandkids out of the very small wages she receives. In her letter, she says, most of their money goes for children, grandchildren, rent, gas, food. Do you see where this is going? Because of this, I can't even afford hygiene. If my family could send $100, NDOC would take 10% for the savings, then the 80%, which is now 50% for restitution, that leaves us $10 to buy one box of tampons. NDOC gives us 7 pads per month. Can you imagine making a 3-year cycle on 7 pads? I would love to be able to wash with real soap, not the lie they give us, even once in a while, not to mention some food, coffee, or ibuprofen. What would you sacrifice for your loved one? How would it feel to know you had to choose between your mother eating or your child eating? These decisions have consequences on real life people and families, and you just can't separate them by when they hit the send button on money. It doesn't work that way. I'm in opposition of SB 22, and it was presented because it is dangerous and reckless for families and incarcerated people. Help us have some degree of certainty that we won't wake up on July 1st and be back in the position we were in on September 1st. Thank you.
Thank you, caller. Caller with the last 3 digits, 746. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hi, my name is Charisse Lothmer, CharrisLothmer. My loved one is incarcerated at Warm Springs Correctional Center. While we are not directly impacted, it is ludicrous to think that we would not all be impacted. As others have said, we stand together as a community against SB 22 and the power it has given Director Daniels to tear our lives apart. Yes, he is implementing Marshall's Law, but nowhere did Marshall's Law require 80 to 100% deductions. Nowhere did it require to eliminate the gift coupon program in order to ensure he could rate families and incarcerated people of every penny, not leaving only inmates, but families as well hurting. I want to share a piece of a letter from an inmate at Ely State Prison. He begins his letter deeply sorrowful for the impact that his choices have had on his family and also on the victim and their family. He acknowledges he owes restitution and that given the opportunity, he will take responsibility, but once the state chooses to incarcerate someone, there is obvious acknowledgement that that person does not have an actual income or an opportunity at a living wage. Even if they are working in a prison, they don't earn a living wage, and living in prison isn't free. I would like to share a piece of this letter as he describes the impact of it on his incarcerated family. Allow me to briefly touch on my family situation. My wife is essentially a single parent due to my poor choices. She has left working full time while overseeing remote learning for our 4 youngest children due to the pandemic. She is struggling to keep her job and food on the table and housing. And our oldest child lost their job and moved home due to COVID-19. Needless to say, there isn't much left over. In September, she managed to send me $20, and that was difficult to come by. She was charged a hefty fee to send me the money, $8 to send $20. By the time NDOC took deductions, she paid $28 for me to receive $12.25. No one is denying that victims deserve restitution. Oddly, many of the women who you have heard from today and many letters from the incarcerated people have been victims of crime and not just offenders. Our concern is how this is done and devastating impact that the Director of Prisons and ultimately the BPCOC think that 80% or even 50% is practically nothing is reasonable. We are also just, okay, Director Daniels cannot be trusted with this, and I oppose SB 22.
Thank you so much.
Thank you, caller. Thank you, Chair. Thank you, caller. If you've recently just joined our call, we are currently on opposition testimony for Senate Bill 22. If you'd like to provide opposition testimony, please press *9 now to take your place in the queue. And with that, Chair Scheibel, there are no more callers to give opposition testimony at this time.
All right. You're indicating there are no callers in the queue to give opposition testimony?
I do have 3 callers currently, Chair Scheibel, but they may have anticipated the neutral position.
Okay. I'm going to keep it open for opposition testimony, and let's go to the first caller who's currently in the queue, and they can let us know if they're not in opposition.
Thank you, Chair. Caller with the last 3 digits, 117. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hello, my name is Nicole Williams, NICOLEWILLIAMS, and I reside in Senate District 17. I'm here to share a letter from an incarcerated person impacted by the revision in September and their concerns and thoughts about it. To take 80% or even 50% of people's earnings as well as gifts sent to them by their family says to that person, you are less than nothing, and we can and will take from you whatever we choose. Obviously, that is a really horrible feeling to know that because of your past, you will be crushed at every opportunity. Under no circumstances can you call it fair or reasonable. We are already being punished for a crime by the loss of our freedom. Restitution is technically not a punishment for the crime. Restitution is repaying, restoring, or compensating. While the deductions aren't intended to be punishment, the way they have been implemented have clearly resulted in that anyway. Then there is the impact on families. I only have my mother. If I tell my elderly mother I need a deodorant and the deodorant is $2.50 and she has to pay another fee to send me the $2.50, let's say $5, and then to offset the deduction, she has to spend $12 plus the fee. She has to send $17 for me to get a $2.50 deodorant. How is that reasonable? My mother is a law-abiding, tax-paying citizen who is just trying to help me because she loves me, regardless of what brought me to prison. We have people who care about us and only want the best for us, even if that only means a new deodorant. Justice in its purest form is about balance. That's why the scales of justice, right? The balance between crime and punishment and rehabilitation. These decisions do not have balance, balancing the needs of the victims with those of an offender. We stand with others before us and oppose SB 22 in its current form. There is no balance, and the director has proven that he has no interest in finding balance. Thank you.
Thank you, caller. Caller with the last 3 digits, 529. Please press *6 to unmute yourself. Then slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Hi, my name is Aurelia Rodriguez, ARELI-RODRIGUEZ. I am here today to read a portion of a letter written by one of members who is incarcerated and the impact all of this has had on her family. My hope in writing is to bring attention to the effects that the change to inmate deductions bring not only to inmates, but to our families as well. First, I understand the reasoning behind Marcy's law and agree that victims deserve restitution, but I am the one that caused the pain, and only I should be the one that makes these payments for restitution. If someone pays it for me, handles my consequences, it allows me to avoid the consequences myself. Taking care of your own obligations is a part of a restorative process that heals people. I also understand from my mother's perspective, she is the only person that has remained supportive of me through my incarceration. She also now cares for my 7-year-old daughter and consequently rarely can give me financial support. I have survived in prison on a $20 per month I make for working within the facility. Even from that, I send $5 home every month to help my mom. Even if it only pays for a field trip, I gave what I could. I know I can't change my poor choices that I made or heal the wounds that I have inflicted on my victim, my mother, my daughter, but I can take responsibility on my own for my own mistakes. These deductions aren't only about the money, but now I can't afford phone time to call my mother and daughter and try to maintain a relationship with both of them. I know that the director said that our families can buy phone time for us, and that is half true, but only true if they have the money to purchase it in the first place. The biggest indicator of my successful transition home is maintaining community and family connections. That has now become impossible. I understand there are many factors to consider, but I hope my letter served its purpose in broadening your perspective. For all the reasons previously mentioned, the fact that director still has not been 100% truthful and families have not been able to have a seat at the table to show the other side of the truth, because it is clear that there has been little interest in the whole truth. I stand with other families and oppose to SB 22 in its current format. Thank you.
Thank you, caller. And as a reminder for our participants in the public comment call, we are currently on opposition testimony on Senate Bill 22. If you'd like to provide opposition testimony today, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 130, please slowly state and spell your name for the record. You will have 2 minutes and may begin now.
Good afternoon, Chair Scheibel and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINESAUNDERS, and I'm the Policy Director with the Progressive Leadership Alliance in Nevada in opposition to SB 22. I just want to echo the sentiments of those who spoke before me and ask that you adopt the proposed amendment. Thank you.
Thank you, caller. Caller with the last 3 digits of 606. Please press star 6 to unmute yourself, then slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon. My name is Amber Cannon, AMBERCANNON. First, I want to thank the Senate Judiciary Committee for taking time to listen to us. I do have a loved one who is incarcerated at Warm Springs Correctional Center, which is located in Senate District 16, and I am here today to speak as a victim who is owed restitution, and also to speak on behalf of an impacted family who can't be here due to work. Her name is Nikki Graves, and this is what she has sent to us and asked us to tell her your story. Nikki writes, I am writing in regards to the struggles myself and other families are having due to the revisions to AR 258 and our fear of that power for Director Daniels and the NDOC to become a law. I have 4 children to support as well as rent and bills to pay. I do my best to send money to my incarcerated family for personal items and food. Although I work, I don't make as much, and the pandemic has made that inconsistent. It's not fair to the families that NDOC is taking our hard-earned money to pay restitution. I understand that they owe restitution and their victims need to be paid, but they are already at the lowest point of their lives, and these revisions and restitution steal the last shred of dignity that they have. Their last hope is to be seen as a human being, even taking it from their wages, which is basically slavery anyway. Let's be honest about that. It is not humane to take what little else they have to hold on to. Do we continue to tear down people and kick them while they're still down? Do we never even do grace or mercy? Eventually, most of them return to our communities. Our fathers, sons, mothers, sisters, and neighbors. Do we want them to be a shell of the person that they were when they were in? We all need to survive. Everybody makes mistakes, and they are paying for theirs with their loss of their freedom, and they should be held responsible for restitution. But I do not believe that that was the purpose of Marcy's Law. To force inmates and their families to break their spirit. SB 22 basically legalizes the oppression that NDOC has instituted with the revisions to the AR. It is not reasonable. It is abuse, and it was never required by Marcy's Law. No excuses. It is time for us to do the right thing. Please do not let the director have this level of unchecked power. I oppose SB 22 as written. On behalf of myself, I also oppose SB 22 as written. Thank you very much.
Thank you, caller. And once again, if you are currently in our public comment call today, we are currently on opposition testimony for Senate Bill 22. If you'd like to provide opposition testimony, please press star 9 now to take your place in the queue. And Chair Scheibel, there are no more callers to give opposition testimony at this time.
All right, I am going to make one last call for opposition testimony. If you wish to testify in opposition to SB 22, please press star 9 now, and I will wait about 30 seconds for anybody still wishing to testify in opposition to join the queue.
Thank you, Chair. Standing by.
And Mr. Kyle, do we have anybody in the queue to give opposition testimony on SB 22?
There are no callers at this time, Chair Scheibel.
All right, seeing as we have made the last call for opposition testimony and nobody has joined the queue, I will now close opposition testimony on SB 22 and open the floor for neutral testimony on SB 22.
Thank you, Chair. To testify in neutral on Senate Bill 22, please press star 9 now to take your place in the queue. Once again, to testify in neutral on SB 22, please press star 9 now to take your place in the queue. And Chair, there are no callers to give neutral testimony at this time.
All right, as we did with support and opposition, I will make one final call for neutral testimony and give you about 30 seconds to hit star 9 if you wish to testify in the neutral position today. Mr. Kyle, is there anybody in the queue to give neutral testimony?
Chair Scheibel, there are no callers at this time.
All right. Seeing as there are no more callers to give testimony in any position on SB 22, I will now close the hearing on SB 22. That takes us to the last item on our agenda, public comment. Public comment will also be limited to 2 minutes per person. And Mr. Kyle, if you would go ahead and start us off. Not that you need to make a public comment, but get people on the line for public comment.
Yes, thank you, Chair. If you would like to give public comment this afternoon, please press star 9 now to take your place in the queue. Once again, if you'd like to provide public comment this afternoon, please press star 9 now to take your place in the queue. And Chair, the phone lines are open and working. However, there are no callers to give public comment at this time.
All right, thank you so much for your help, Mr. Kyle. Thank you so much to the members of the committee and our presenters here today who I know listened very carefully to all of the testimony and had a very fruitful hearing today. I appreciate all of your participation. That concludes our meeting for today. We will be meeting again on Monday. That would be March 8th at 1 p.m. And we are now adjourned.